I'm Drew Stevenson, and this is a lecture for my administrative law class about the case Decker versus Northwest Environmental Defense Center. This is a U.S. Supreme Court case from 2013 about Auer deference for agency interpretations of its own regulations. Now, for my students, I know it's confusing in administrative law. We have all these different types of deference that we talk about: Chevron deference and Skidmore deference and Auer deference, and you may have heard of Hearst deference. And now these things actually matter when we get into court, because if you think about like the levels of scrutiny that you applied in constitutional law, this is almost like the opposite. These are different levels of deference that we apply to, and different types of cases fit in each of these categories. So for example, Chevron deference is for agency interpretations of their statutes that are ambiguous. Auer deference is agency interpretations of regulations that the agency itself promulgated. And so the basic idea is that for the last several decades, the courts have said, well, the agency wrote this regulation, so obviously they know what it means, and their interpretation of something that's ambiguous. Think of a word like substantial or reasonable, or a point where the interpretation, the regulation is silent and the agency is inferring things. And the court would defer to the agency's interpretation of its regulations unless it was plainly erroneous, which is a very deferential standard, even more deferential, I think, than Chevron. Well, in the last 20 years or so, agencies have been invoking Auer deference more and more often, and the Supreme Court has been getting more and more uncomfortable with the situation and how long of a leash the agencies have in this regard. And that really comes out in Justice Scalia's dissenting opinion in this case. So that's a little way of setting up the problem here. Let's look at what happens in Decker. So the critical question in this case is whether the EPA should receive Auer deference from the courts for its interpretation of its own regulations about the Clean Water Act. So the Clean Water Act is a pollution control law, obviously for water, and it's sort of addressed to the EPA, or in other words, Congress entrusted the Environmental Protection Agency with implementing the Clean Water Act, which it mostly does through a permitting system, and those permits come with a lot of strings attached. So the majority in this case from the Supreme Court says yes, that the EPA should get deference from the courts, but there's a noteworthy dissent from Justice Scalia calling for the abandonment of Auer deference, and Justice Scalia wrote the opinion in Auer. So it seems like he doesn't quite say this, but he wrote a series of dissenting opinions near the end of his time on the court, basically expressing regret over his Auer opinion. And it was, I think he thought he had created a monster. So let's look at what happens here. By the way, his dissenting opinion gives us a really useful quote that's for defining Auer deference. And I've pulled that out for you here at the beginning. I usually talk about dissenting opinions at the end of my videos, but this will help you understand what most of this opinion is talking about. The canonical formulation of Auer deference is that we will enforce an agency's interpretation of its own rules unless that interpretation is plainly erroneous or inconsistent with the regulation. So again, the agency would have to do something pretty crazy to be plainly erroneous. So they're going to win most of the time if the court applies Auer deference. Now, the Clean Water Act and its implementing regulations require permits for letting stormwater runoff flow into nearby streams and rivers. If you look at this picture, it's not from this particular case, but it nicely illustrates the type of pollution problem we're talking about. If these discharges are deemed to be, quote, associated with industrial activity. So this is a kind of a perennial problem in water pollution, the idea that when it rains really hard, and that rain falls on the ground, it eventually runs off into ditches and drainage pipes and so forth, and eventually is going to make its way into nearby streams and then probably lakes and rivers. And in rural areas where we have big logging operations, that's the problem in this case, or sometimes massive clear cutting of forests for farming and agriculture, or grazing cattle, we end up getting a lot of soil mixed into this rainwater runoff or sediment. And as you can see in the picture here, now, if you haven't studied environmental law, you might just call this muddy water, right? But it's muddy because there's a lot of loose dirt or sediment in the water. And that eventually makes its way into the river. And that's where it creates a lot of problems. It raises the bottom of the river or lake that it's in, so it becomes more shallow, and that affects the temperature. The sediment changes the water composition and how clear it is, which kills some of the fish and the plants and things like that. So when it rains, even though nobody's dumping toxic chemicals, let's say, we just get a lot of loose dirt from these agricultural or logging areas into these ditches and gullies and streams and so forth that would make their way eventually into a river where it causes a lot of problems. So here the question is whether stormwater runoff from logging roads should count as being, quote, associated with industrial activity, which is what the regulation says. If it is associated with industrial activity, they have to get a permit. And again, these permits are a lot of hassle, and there's a lot of hassle involved. And so for purposes, and I don't want to get too far off track or bore you to death with talking about the Clean Water Act, but just the quick and dirty what you need to know for this case. Each road under the Clean Water Act, any roadside drainage ditch or a drainage pipe or channel is going to be called a point source. And so what I want you to think of is like a pipe that's leaking stuff into into a stream or a river. We're going to regulate every place where an effluent, some sort of flowing liquid, makes its way into our water systems. And so these are the building blocks of what we call the NPDES, and you don't have to remember that from my class, permitting system the EPA uses to control water pollution. In other words, all of our regulation about water pollution in the United States is built around a permitting system. And again, these permits come with a lot of conditions and strings attached. And the way we know if you need a permit is whether something is a point source. So the EPA looked at roadside ditches from logging, which sometimes get very muddy, like the one I have in this picture, and said that the logging companies actually don't need permits. And so a wilderness conservation group sued. So the EPA interprets its regulation about industrial runoff to exclude the type of stormwater drainage from logging roads at issue here. In other words, they said, no, we were thinking of factories and big manufacturing facilities where there's a lot of like toxic chemicals that get dripped and spilled on pavement, and the rainwater washes those into the streams and rivers and lakes. So the Supreme Court here, this is kind of the spoiler, concludes that the EPA's determination is a reasonable interpretation of its own regulation, and in consequence, the EPA receives deference under this longstanding doctrine from Auer v. Robbins. This is another picture where you can kind of see the muddy water from a tributary meeting the cleaner water from a larger body of water. The court says it was reasonable for the EPA to conclude that these conveyances are directly related only to the harvesting of raw materials rather than to, quote, the manufacturing, processing, or raw material storage areas at an industrial plant. And says that the regulatory scheme as a whole leaves open the possibility that the permit requirements apply only to traditional industrial buildings like factories. In addition, the EPA, it's worth noting, and this was actually a pretty good point, has been really consistent about this over the years. So it's not like they were changing their rule back and forth or just giving a break to logging companies all of a sudden. This had kind of always been their position. And the court likes it that they've been consistent over time. If you're starting to get bored, I'm worried that you're getting distracted, not paying attention. So Lucy and Rosie, my dogs, want you to stay focused. Okay, let's talk about Justice Scalia's dissent. Remember, Justice Scalia wrote the original Auer v. Robbins opinion, and he begins his dissent by saying that, look, we've been doing this for decades and enough is enough, and then launches into a prolonged attack on Auer deference. Also note, Justice Roberts wrote a concurrence that says that he also wants to revisit the Auer issue. He thinks that we have a problem, but he thought that this was the wrong case to do it because he actually thought that the EPA was on the right track here. But I did agree with Justice Scalia that there's this kind of problem looming about Auer deference. So Scalia says that the question should really be, this is what he wants to do instead of Auer deference, is just what's the fairest reading of the regulation? And that this is the same as asking if the agency's interpretation is, quote, inconsistent with the regulation. So we could just stop talking about Auer deference and just ask, what does the regulation say? And is the agency's opinion inconsistent with it? He also says, and this is very clever, that Auer deference gives agencies a perverse incentive to promulgate intentionally vague regulations so they can interpret them however they want later and then just claim deference from the courts. And he gives some examples indicating that that's exactly what's been happening. Okay, so what's the epilogue from Decker? You know that the logging companies won basically because the EPA won. But inspired partly by Scalia's dissent and Roberts's concurrence in this case, in 2019, litigants asked the court to formally abandon Auer deference in the case Kisor v. Wilkie, which, and I'm mentioning this because it's not in my casebook, and it really is the case that probably should be instead of the Decker case, because it's the latest word on Auer deference, and they made some changes. So the Kisor decision, just so you know, and I have a separate video I recorded about it, preserved Auer deference, but limited it for the future with a multi-factor test that courts must apply. Okay, and that concludes my lecture about the Decker case.